Hey everyone, Noah's Irby here. This is one of a series of videos exploring topics in California politics. In this video, we're going to look at the state judiciary, the court system in California. In a similar role as played by the federal courts at the national level, the California judiciary plays a crucial role in the state's governance, upholding the principles of separation of powers and ensuring checks and balances within the state government. Much like the federal court system, the California judiciary does this by performing a number of functions. The primary role of the judiciary is to interpret and apply laws to resolve disputes and ensure justice. Judges in California courts interpret the state's constitution, statutes, and regulations, as well as common law principles to make legal determinations in cases brought before them. The California judiciary safeguards individual rights and liberties enshrined in both the state and federal constitutions. Through judicial review, courts can declare laws or governmental actions unconstitutional if they violate the rights protected in these constitutions. The judiciary ensures fair and impartial administration of justice. Judges and justices are responsible for weighing evidence, applying the law, and making decisions to uphold principles of due process, equity, and access to justice. And finally, the judiciary provides a forum for the resolution of various disputes, ranging from civil cases involving contract disputes or personal injuries to criminal cases involving violations of state law. In exercising these powers, the court has the power of judicial review, or the ability to strike down laws passed by the state legislature or determine the actions of the executive branch unconstitutional. In doing so, it performs a similar role in checking the power of the other branches of government as we see in the federal courts. California's court system follows a three-tiered structure consisting of three levels of courts: the California Supreme Court, the Court of Appeals, and the Superior Courts. In general, cases begin their journey through the state court system at the Superior Court level and then gradually wind their way up on appeal. This three-tiered system ensures that cases can be heard and resolved at different levels of the judiciary, providing avenues for appeal and ensuring efficient administration of justice. Let's explore each tier in a bit more detail. The California Supreme Court is the state's highest court and serves as the final authority on matters of California law. It consists of 7 justices, including the Chief Justice, who's responsible for administrative duties. The Supreme Court primarily exercises discretionary review, meaning it can choose which cases it will hear. However, it is required to hear certain types of cases, such as cases involving the death penalty appeals. The decisions of the California State Supreme Court set precedents for lower courts and have a significant impact on the interpretation and development of California law. Its rulings on constitutional issues and statutory interpretation are binding throughout the state. The State Supreme Court also has the power to review the decisions of the courts of appeal. At the intermediate level, there are 6 courts of appeal, also known as appellate courts, divided into districts based on geographic regions. The districts are the 1st, 2nd, 3rd, 4th, 5th, and 6th District Court of Appeals. Each district has its own courthouse and panel of justices. The courts of appeal primarily review decisions made by the superior courts. They handle appeals from trial courts, including both civil and criminal cases. The role of the courts of appeal is to review lower court decisions to ensure they were made correctly and in accordance with law. They examine legal arguments presented by the parties, review the trial record, and determine if any errors occurred during the trial process that might warrant a reversal or modification of the lower court's decision. The decisions of the courts of appeal are binding on the trial courts within their respective districts, but are not binding on each other. However, they can be a persuasive authority for other districts and trial courts when deciding similar cases. Finally, the superior courts are the trial courts with general jurisdiction in California. There is at least one superior court in each of California's 58 counties, with more populous counties having multiple branches. Superior courts handle a wide range of cases, including civil, criminal, family law, probate, and juvenile matters. Superior courts are the initial point of entry for most cases where evidence is presented and trials are conducted. Judges in superior courts make determinations of fact and law, and their decisions are based on the interpretation of statutes, case law, and constitutional provisions. They preside over jury trials, hear motions, and issue rulings in legal disputes. The superior courts also serve as appellate courts for decisions made by lower courts, such as small claims courts and certain administrative agencies. Unlike federal judges, who once appointed by the president and confirmed by the Senate have lifetime tenure, judges in the California judiciary must also secure approval by the voters in order to be retained. When vacancies arise in the judiciary, the governor has the authority to nominate individuals to fill those positions. The governor's selections can have long-term impacts on the ideological direction of the judiciary, as they often choose individuals whose partisanship and political principles align with their own, while also considering candidates based on their personal and professional qualifications, legal experience, and judicial philosophy. To be considered for the California Supreme Court, potential justices must have served as an attorney or judge in California for at least 10 years and must be a member of the state bar. To be considered for the Superior Court, candidates must have at least 7 years' experience. But interestingly, the process actually begins with the California Commission on Judicial Appointments, a 3-member panel appointed by the governor and responsible for recruiting and screening candidates for judicial appointments. As part of its mandate, the commission must hold public hearings on each candidate under consideration in order to give the public an opportunity to provide feedback on potential nominees. The commission forwards a list of recommended candidates to the governor for consideration. While there's no formal minimum or maximum number of nominees, the CGA generally provides a list of between 3 and 5 candidates for the governor to consider. Legally, the governor may also consider a candidate not on the CGA's list, but this has been exceedingly rare in practice. The governor then appoints a candidate to a vacant position. The nominee then serves out the remainder of the current term, a maximum of 6 years at the Superior and Appellate Court levels and 12 years at the Supreme Court level. After that, they face the voters in a retention election. In that retention election, voters are asked a yes-no question as to whether they want to retain the specific judge on the court. If the judge fails to secure a majority of the vote in favor of their retention, they're removed from the position and a new opening on the court will need to be filled. This retention election provides voters an opportunity to have a say on the continuation of a justice's tenure. However, it's worth noting that judges rarely face rejection by the voters unless there is public outrage or significant campaign efforts against them. Indeed, over the past 50 years or so, sitting justices and judges have won roughly 99% of their retention elections. Unlike at the federal level, California justices can also be recalled by the voters through the recall provision in the state constitution. In practice, however, this is uncommon. The last judge to be recalled was John Dunn, who was recalled from his position as a Superior Court judge in 1932 after being accused of corruption. But despite the rarity of its use, the recall provision and the requirement of retention elections are designed to ensure accountability and allow the public to express their confidence or dissatisfaction with sitting judges. The California judiciary faces significant challenges that impact access to justice and efficient functioning of the court system. First, the budget allocated to the judiciary is often insufficient to meet the growing needs and demands placed upon it. This underfunding has resulted in numerous challenges, including limited court hours, reduced staff, outdated technology, and insufficient resources for court operations. Insufficient funding leads to delays and prolonged court proceedings, exacerbating already lengthy case backlogs. It hampers the ability of courts to hire and retain qualified personnel, including judges, court interpreters, and court reporters, which directly affects the administration of justice. This funding shortfall has been particularly pronounced in the underfunding of the public defender's office. A public defender is the court-appointed lawyer provided for indigent criminal defendants. According to the National Association of Public Defenders, California ranks 49th in per capita funding for public defense. This underfunding of the public defender's office results in increased caseload, which can sometimes be too large to provide an effective criminal defense. It also increases the cost of the legal system by creating delays in the process and threatens to result in innocent people being wrongly convicted. Budget cuts have also impacted support services such as the clerk's offices and self-help centers, which provide valuable assistance to individuals navigating the legal system without legal representation. The reduction in these services further hampers access to justice, particularly for low-income individuals who might not be able to afford legal representation. And it has reduced the number of support staff, including court interpreters and court reporters, which further strains the court system. The shortage of court interpreters in particular affects the ability of non-English speaking individuals to understand and participate effectively in court proceedings, impeding their access to justice. The scarcity of court reporters poses challenges in accurately documenting court proceedings. Without proper transcripts, it becomes difficult to review and appeal decisions, potentially compromising the fairness of the judicial process. Mandatory and enhanced sentencing laws have had a significant impact on mass incarceration in California. These laws have led to longer prison sentences for a wide range of offenses, including drug offenses, property offenses, and violent offenses. The 3 strikes you're out law was one of the most controversial mandatory sentencing laws in California. This law mandates a 25 years to life sentence for any person convicted of a third felony, regardless of the severity of the third offense. The law has been criticized for its harshness and for its disproportionate impact on people of color. As a result of the tough-on-crime policies in the 1980s, the state's prison population skyrocketed, growing from around 12,000 people in 1950 to its peak of around 163,000 by the mid-2000s, before declining to around 120,000 in recent years. The increased prison population has also led to an increased cost of incarceration. In 1990, the state spent approximately $1.5 billion on corrections. By 2020, that number had increased to over $10 billion a year. Mandatory and enhanced sentencing laws have also had a disproportionate impact on people of color. In 2020, for example, Black Californians, only about 15% of the state's population, comprised about 38% of the state's prison population. And in recent years, there have been a number of proposed reforms and revisions to address mass incarceration in California. These proposals include reducing the use of mandatory sentencing laws, expanding early release programs, and investing in programs that help people reintegrate into society after they're released from prison. The passage of Assembly Bill 109, also known as AB 109, in 2011 started the process of prison realignment in California. In essence, this process attempted to shift responsibility for certain low-level, nonviolent, non-serious, non-sex offenders from the state to the local city or county governments within the state. While AB 109 was passed in response to the state budget crisis and had as one of its goals to reduce the prison costs and the problem of overcrowding in California prisons, the process has been controversial. Under AB 109, local governments are responsible for providing supervision and treatment for these offenders. This can be done through a variety of programs, including probation, parole, and community-based treatment programs. But the realignment process has been controversial. Some people have argued that it's led to an increase in crime rates in some communities, while others have argued that it has been successful in reducing overcrowding in state prisons and saving the state money. But that concludes our overview of the judiciary in California. Please leave any questions you have in the comments section below, and thanks for watching.